Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride.
Hi, everybody. Oh, Jesus. Okay. We're gonna have a night like that, are we? Oh, we're gonna have a night like that, are we? Hi, I'm gonna put on court. I hope you're all having a wonderful day. I was until just right now. I checked in with the internet moose. I hope everybody's doing well. If you have already eaten, which go ahead and someone fucking shoot it. Go ahead and tell me what you had for dinner. Tell me what you wish you had for dinner. Thank you. Yeah. Great dress. There's only one.
Can you hear me?
Yes. I'm going live here, so let me just. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2023-2780 DP, Taylor Coyer versus Jalen Naylor. Today is Monday, July 1st, 2024 at 10 a.m.
Court will note the appearance of Ms. Paisno on behalf of the plaintiff, Mr. Scott on behalf of the defendant. This matter is before the court on the plaintiff's motion for child support. I have read all the pleadings in this matter. It does appear based upon that the court is going to have an evidentiary hearing to decide the ultimate issue, as there are a number of issues the court has to decide in this matter. Is there anything else you have to add, Ms. Paisno?
No, Your Honor, I do believe that the court will need an evidence. Would ask if this court could start some temporary support. My client has gone without support on this minor child in September. Okay.
Mr. Scott, your thoughts?
Yes, thank you, Your Honor. I have reached out to Ms. Paisno. We have been working well together in my judgment. And I did suggest that a sum of $2,000 per month be granted presently pending your review and or the friend of the court's review, because as the court may be aware, if Mr. Naylor had paid anything, it could have been determined involuntary payment. And so I'm happy to enter an order at this time at $2,000 per month if it's within the court's discretion to do that at this time, adjusted either upward or down.
This is the football player. I don't know if we watched this. It didn't really ring a bell when we looked at it, but I think this guy's a football player. We're gonna watch it. I don't have anything else. I was looking through my thingamajigger and yeah. Football player. Also Leslie. She was involved in that other really long case.
we're depending on how you decide or how the front of the court might rule.
Okay. Well, the court does note, at least Mr. Scott in his answer says at one point the parties had agreed to the $2,000 per month. I don't know if that's the case, and I don't know if the proofs will establish that, but at this point, the court will order the sum of $2,000 per month commencing on today's date, July 1 each month thereafter, subject to obviously modification as we proceed. And the court will schedule an evidentiary hearing to determine all the issues that we have to arrive at the correct support amount. Anything else, Ms. Paisno?
Nothing further, Your Honor.
Mr. Scott?
I have nothing further, Your Honor.
Okay. Ms. Paisno, if you would submit that order under 7 day, we will conclude and then we'll be in touch with you. Is there anything else you need to do, Ms. Paisno and Mr. Scott, before we have an evidentiary hearing? Because I want to make sure if there's any discovery or anything you're doing that we don't schedule it before that.
We may need to have a brief deposition, Your Honor, just on some of the issues, but it would be not a great deal of time is necessary, probably 30 to 45 days at the most.
Okay. Ms. Paisno?
Attorney Scott and I have been working well together, transferring information as needed. So it's be appropriate.
Okay. What we'll do is we'll probably set it sometime later August. If that works into everybody's schedules, and we'll be in touch with you to see what works with your schedules and your clients as well. And then we will have a hearing. I don't think the hearing would take more than a couple hours, so we'll schedule it at that point.
Your Honor, just a point of clarification. My client is in Minnesota. Is it okay with the court to do that via Zoom?
Yes.
Thank you.
Okay. Thank you. You're free to go. Have a good day.
All right,
Thank you,
thank you, Your Honor.
Thanks, Jayla.
Thank you.
See you, bud.
He does not make 960 million. Hold on, Lisa, is that true?
Please unmute.
No, please mute. Is that true? To the Sorry. Gonna be a maximum. She ugh. Oh, he is. Oh, so I thought he was a college football player. He's with the NFL. Well, Jesus. 8 hours of easement portal hell. What was that? Hi, Ed. Hi, Ed C. Ed C. Sounds like Etsy.
Good morning.
Good morning.
Caitlin Carr.
Yes,
Oh. Okay, and what case are you working?
I'm here on behalf of the Polaris First Evolution.
Okay, and
Were you guys watching that original easement case? I'm still, I don't know if I still have it, but that case that we had where the guy was pro se, there was an AR-15 involved. It was in the Sweetie Poo case, or the Sweetie Pie, or the Honey Poo.
you're here representing?
On behalf of plaintiff.
Benjamin,
Yeah, Ben Sobchak is also going to be appearing.
all right, I'll place you in the waiting room.
Thank you.
Thank you. Please unmute.
Sweetie Poo, remember that? That was a crazy case. Yeah, probably not. Hi, Cole. How are you? I feel terrible. I think we've watched this, you guys. Where's my lighter?
All right. Huntsman, you are here on Hercules, Bradbury.
Fafaric.
Calling case 2024-549 CB Hercules Material Holdings versus Schaefer Ready Mix Incorporated et al. Today is Monday, July 1st, 2024 at 10:06 a.m.
Court would note the appearance of Mr. Bradbury on behalf of the plaintiff, Ms. Hansma on behalf of a defendant, and Mr. Fafaric on behalf of a defendant as well. This matter is before the court on the defendant's motion to compel. We had been in court just last week and addressing various issues in this particular case. Defendant, you can proceed. I've read all of the pleadings, so you don't need to reiterate that. If you just want to respond to, again, the plaintiff's answer, and then we can proceed.
Certainly, I appreciate that, Your Honor, and I trust that you did have a chance to look at all of that. I think it's important in context to understand that my client, Schaefer Ready Mix, is in this case as a defendant because the plaintiff has asserted two tort actions against my client, interference with contract and interference with business expectancy. And so, as you might imagine, defending those claims requires that we understand what specific acts they believe that Schaefer engaged in that would give rise to liability. And so when we prepared these discovery requests, the thrust of them is to figure out what specifically is it you're alleging we did here. And what we're seeing is kind of the classic, well, we know you did something wrong, but we won't know what it is until you tell us. And so where I am in discovery is,
so your client's not willing to tell them?
Well, my client says we didn't do anything wrong, as you might imagine. So that's kind of where it's turned into this chicken or the egg situation, but they're the plaintiff.
Okay.
And so if they're saying that, Schaefer, you have our confidential and non-public information, which is actually a term of art they use in their complaint, and you used it to interfere with our contracts and our customers, I say back, explain to me, obviously you don't have to put your trade secrets in court filings, but explain the nature of the information you're claiming we have and how we used it, when and with whom. So this is your complaint, your allegation, and then I get back an objection saying none of that is relevant. And so, and that's the nature of the responses I got to each of my requests. A lot of times it's, well, discovery is not over yet. And as you might recall, Your Honor, discovery was over before you extended it this past week. And so here we are at the end of discovery, and I'm asking, tell us specifically what actions Schaefer took. By way of example, they'll say in their complaint that you went out and you solicited Walbridge, by way of example, this contractor for work. And so I ask in discovery, when and to whom? What conversations are you referring to where you're saying this improper solicitation occurred? And I get nothing. And so if the answer really is, and I'm sure this does happen all the time before your court, if the answer is we think something bad happened, but we won't know until we're done with discovery, that's why the request to admit are included. Because I think the answer right now is we don't have evidence, we think we're going to find it. But if that's the answer, then what I want is I want it under oath that this, to this date, this is every example we know of that would constitute facts giving rise to our cause of action. If they find more in discovery, which they won't, they can supplement. And then when that discovery period is over, we'll be ready for a motion.
Okay, thank you.
which they won't. I don't think we did listen to this. I think we maybe listened to the first case because it was the football player. And then I don't recall listening out of it. Also, this dress, it can go off the shoulder or you could do like one down. Anyway.
Mr. Paparik, what's your position?
I concur with everything that was just said.
Okay, thank you. Mr. Bradbury, anything else?
Yeah, just briefly, Your Honor, because I won't reiterate the things that we wrote in response to the motion. But I think the context of the case, and especially the context of at least my understanding of the parties trying to resolve the case while discovery was ongoing, is important. So my understanding again was that the parties conducted some written discovery in advance of mediation. I assume on both sides in order to gather some facts and some information which would inform their positions leading into mediation. Mediation, of course, hasn't resulted in a settlement of the case. And so then it was, from plaintiff's perspective, all right, well, investigation phase 2 now, I guess, is underway because we were not able to resolve the case after that round of initial discovery. And that's where we are, Your Honor. So again, the context of the situation, I don't think is one in which we were truly at the end of discovery. We were nearing the end of the initial discovery cutoff that the court set, but I don't think there was much question, at least in the plaintiff's mind, that what was intended on both sides all along was to extend discovery beyond mediation if necessary, and with the court's permission, in order to conduct more substantive discovery, written discovery, and depositions.
Okay,
Judge,
well, go ahead.
That simply is not accurate. There was never any such understanding or agreement. We had a court order that set forth the parameters of this case and discovery. And as I mentioned last week, we had served discovery early on, and it took 60 days or better for them to respond to it. It wasn't because we were trying to just limit certain things and obtain limited amount of information prior to conducting a mediation. And there was no discussion at the time of mediation of extending discovery any further. We were working under the presumption, the understanding that this case was going to trial here shortly. So there wasn't any deliberate effort to limit our efforts of trying to understand what was being pled in this case whatsoever.
Okay. Well, what the court's going to do, and the court does recall the motion last week where we did extend the discovery. What the court's going to order is that the plaintiff would respond completely to all of the discovery requests in accordance with the Michigan court rules within 14 days of today's date. If they fail to do so, the defendants can proceed with their summary disposition motions that they'd referenced last week. And then at that time, based upon the summary disposition motions, the court will decide whether the responses and that were sufficient at that time, because on a motion day, I don't have time to go through all of the again, interrogatories, requests for production of documents, or requests for admissions, but we will have to obviously decide that at the time of summary disposition if that's the appropriate action. So, Ms. Hansman, you can prepare an order and submit under 7-day notice.
I will do that. Thank you, Your Honor.
Okay, thank you.
Have a great day.
Thank you.
Happy birthday, dear Miss Carrie. Happy birthday to you.
Good morning.
Good morning.
No, never mind. We've seen it. I'm not watching it again. I fucking remember him. Never mind. I will find something else for us to watch. Oh, oh, it's all coming back. It's all coming back to me now. I don't want to watch them ever again. But I think it is the pop case. So, anyways, um, okay. I do have two super secret files, Bill, but they're on 2x speed. But they're old TPOs. Back from the 1200D days. So if you guys are down to listen to them on quick speed, I've got a case for us. But I'm not slowing it down. I can't do that. I had pulled it up earlier. Super secret. If you're new here, hi, welcome. Thanks for putting up with me so far. Okay. I'm gonna create frame, which means I'm gonna freeze doing something great. So give me a moment and I'll get this for us. I think it's this one.
Contempt and incarceration consequences for any willful violation of this court order.
That really muted? Is it muted now? No, I'm not? Okay. Sorry. I was just saying, actually, I was saying, first of all, thank you, Miracle Mama Cole. $1 for each day in the hospital and 1 for luck. Love you. Good luck. Bill, thank you for being here, but yes, good night. I was saying, see, maybe I should take it as a little bit of a like a godsend that I didn't have to say this, but anyways, I was saying this is Southern Court. This is Georgia. Okay, so these people move slow. So, the judge is a little bit fast, but she took French in college. That's why. I think we might be okay. Let's give it 10 minutes and we'll.
And rules. So at this point, versus Christopher Ramirez, Mr. Ramirez is represented by Attorney Abbasi, and Ms. Rowe is a pro se petitioner. So the way this will work is that I will swear both parties in, and then the petitioner bears the burden of proof in this case by preponderance of the evidence. So she gets to go first. She will tell the court everything she wants the court to know about why she's filed this petition and why she is seeking a continuance of the order for 12 months if she is. And then she will be able to introduce any evidence or attempt to introduce any evidence she wishes to, and we will go from there. Then Ms. Abbasi will have the opportunity to cross-examine her and ask any questions she has regarding any testimony or evidence that's been presented. And then once we've heard from Ms. Rowe and any witnesses and testimony, if there are any other witnesses, then it will be Mr. Ramirez's chance to testify if he chooses to or present any evidence or testimony. Ms. Abbasi, I believe from the filings, was your client arrested in this case?
Yes, he was arrested on May 26th, and the CPO was taken out. It was applied for on the 20. Let me make sure I'm getting this right.
It looks like it was filed on the 30th.
Filed on the 30th. It was granted. The order was signed on the June 1st. So we actually skipped a day in there.
Okay, so I just need to make sure. I'm sure you have done so. And before when it's his turn, I'll make sure I will reiterate that you've gone over with him that anything, if he chooses to testify in this case, can be used against him in his criminal case and can detrimentally affect that criminal case.
Yes, Your Honor. So I anticipate that.
It is. I can't slow it down in here, unfortunately. Oh, I spent a bunch of my energy figuring out members, which is happening after this, and I forgot to find. I'll play it for 1 second.
Later for a breakout room or just to step away and I can speak over the phone to make that decision.
We will do that then. All right, and so at this point, Mr. Ramirez, you would unmute yourself, please, sir. And then if both of you would please raise your right hands, Ms. Rowe. Do you solemnly swear from testimony you're about to give us the truth, the whole truth, and nothing but the truth under penalty of perjury, Ms. Rowe?
Yes, I do.
And Mr. Ramirez. All right, thank you both. You lower your hands. All right, so at this point, Ms. Rowe, you filed this petition. How long have you known Mr. Ramirez?
Since 2016.
And just to be safe, can you state your full name for the record, ma'am?
Rochelle Garvino Rowe.
Okay. And at any point did you start living together?
Yes.
Around when was that?
In March of 2018 to March of 2020. And then when the lease was up, we went our separate ways. And then for 2 years. And then no, it wasn't for 2 years. No, we got back together. Yeah, it was 2 years. We just got back together. So the lease was up March of 2020. And then we just got a lease together again in November 2022.
Okay. And did y'all start dating or in an intimate relationship before November 2022?
Yeah, so we were together when we lived together the first time, and then we separated when the lease was up March 2020, and then we got back together. We started dealing again maybe like August or so 2020 or something like that, and then we started. We got more serious. I believe it was like March 2021 is when we actually made it official and got back together. Like we actually were in a relationship, and then yeah, we've been together ever since. And then we just moved back in here November 2022. We moved back together 2022.
All right. And so why did you file? Well, let me ask you this just to be clear. Have you ever been married?
No.
And do you have any children together?
No.
All right. Are there any shared accounts, monetary accounts, utilities, rent?
Yeah, so there's shared rent. Both of our names were on the lease, and the utilities were in my name. Both of our names are on the lease, and the utilities are in my name.
And do you both get mail there?
I think I get mail. I don't really remember. I've probably seen him get mail here once, like one envelope.
All right. And so why did you file for a petition for a protective order in this case?
So we've had a history of like domestic violence. There's been a history of like aggression and stuff between us getting out of hand. I sent some evidence from like even when we lived together the first time. And it's just everything has just been getting worse. So what caused me to do it?
All right, we have a choice here. I do have fresh. Court, but it's got the shit audio from that other courtroom. don't want the comments later. It's selfish. I don't want to complain comments. We did Tiffany already. Stop. Wait a minute. I'm glad somebody thinks my annoyed look is cute. Thank you. Jim, thank you for sorting that out now that I've changed my mind. I feel terrible. This is what we're gonna do. We're gonna listen to this. Stop. Hamilton. I really like this new dress. I'm a little bit, I should have got a one size bigger. I didn't. I'm a little delulu. That's okay. It's okay.
205-089, it's continued motion regarding request for school change. Plaintiff is in the courtroom represented by attorney Brian H. Gene. Mr. Van Valkenburg, defendant in the courtroom represented by attorney Dennis Reed. The court previously at hearing had the opportunity after hearing by stipulation of parties to meet with the minor child. In this case, the court had the opportunity to meet with the minor child, and maybe I say this too often, but I mean what I say, that you have a bright young child.
He said this last time. This is the same one. Fuck. Not working today. Oh, we can't. I was just. We can't. Really fun plan for members only. Episode. Will we do some? You mean like the fake paternity court? Do real paternity court? Let's see if he says
Our
reverb.
rush file number 26775 GM, this plaintiff's motion
Terrible.
for custody.
I have a theory actually. I mean, if you were I forgot to do that actually. If you were oh my god, it won't even let me on. Yeah, having issues. I am having issues. I'm clicking, but that's not gonna help in the moment. Like it's a um, so it they're throttling. Pitch 4 members only. Pitch I'm StreamYard. There's no other fucking windows of preferred. Cookies are cleared. You know, more room on my computer than I normally. Hurting me. I think we should blame Elon. Put a ticket in. I'm just not gonna do it live, Paul, because I just don't think that's fun for everyone to thing, but I am going to say that. I oh, it's beyond. I'm I'm gonna make only for like no. I'll try that. Seems to work. Here's what I'll say. I'm gonna if you want to come watch, I'm pretty lackadaisical about turning on members. So set up members only. If you get in there before I lackadaisical to change it to members only, then because 1-star review that we're going to be reading together and video that we're going to watch. Yeah, it's just a good little video. We'll watch it together. And look at it. See, now it settles down. But yeah, for like 805, that's in 2020. we could call it. Other fuck. I am, let me, it won't even let me do the. Oh,